My name is Brad Lingo. I'm a litigator at Cheri Spalding and the chairman of the Charlotte chapter of the Federalist Society. On behalf of the Federalist Society and the Charlotte School of Law, I'd like to welcome you to tonight's Supreme Court candidate forum. As many of you know, this is an unusually important election cycle. 4 of the 7 seats on the court will be on the ballot. We're very pleased tonight to have with us all 8 candidates for those 4 seats. Candidates, thank you for joining us. I'd also like to thank a few other folks. Tonight's moderators, Lisa Thaxton of the Charlotte School of Law, Manley Roberts for so wonderfully playing the piano tonight, Leah Sink for helping us with publicity, but I especially want to thank our forum co-chairs, Susan Rodriguez and Tricia McGee. They've done such a great job putting together tonight's event. And now, Susan, if you'd like to come and introduce tonight's moderators.
Well, again, I'm Susan Rodriguez. I'm one of the co-organizers of tonight's Judicial Forum, and I'm also an attorney at McGuire Woods. And I'm also very pleased to introduce tonight our 2 distinguished moderators this evening, Jenna Deery and Dean of Charlotte School of Law, Jay Conison. Jenna Deery is a reporter from WSOC Channel 9 Eyewitness News, where she mainly focuses on covering city and county government in Charlotte. She joined WSOC in October of 2013 and came from the sister station in Dayton, Ohio, after spending 3 years in Montgomery, Alabama. And there she covered state politics. Jenna is a graduate of Samford University in Birmingham, Alabama, and she's originally from Orlando, Florida. Jenna, thank you for being here tonight. Jay Conison became Dean of the Charlotte School of Law in April of 2013. From 1998 until March of 2013, he was the Dean of Valparaiso University Law School in Indiana. He has a JD and MA in philosophy from the University of Minnesota and a BA from Yale College. He practiced in Chicago with the firm now known as S&R Denton. Dean Conison's scholarly and professional work focuses on issues in legal education and the business of law schools. He has served as a reporter for the American Bar Association Task Force on the future of legal education and has been the chair of the accreditation committee of the ABA section of legal education and admissions to the bar. He currently serves as the vice president of the North Carolina Bar Association. Dean Conison, thank you for being here this evening and for Charlotte School of Law support and co-hosting tonight's event. I will now turn the program over to the moderators.
All right, everyone. Thank you so much for joining us tonight for tonight's Judicial Forum. This is a great opportunity for you to get to know the candidates running for North Carolina Supreme Court. And it's a chance for the candidates themselves to share a little bit about who they are and what they foresee with the future of North Carolina's judicial system. As stated before, 4 of the 7 seats on the North Carolina Supreme Court are up for grabs this year, making this a very important election in determining the future makeup of the North Carolina Supreme Court. We first want to start off giving the candidates themselves an opportunity for you guys to get to know them a little bit. A few introductory remarks. We're going to give each candidate 90 seconds to tell us a little bit about themselves. And we'll start with candidates for Chief Justice, first starting with Chief Justice Martin.
Well, thank you, and good evening. I'm Mark Martin, and I have served as Chief Justice for about a month. Let's unite to strengthen our justice system. I have promulgated and issued a comprehensive administration of justice plan that provides for adequate funding for our courts, enhancing technology, using innovation to ensure that we are re-engineering and doing court services in the most efficient and effective manner. Let's ensure that our young people understand the value of civics education and how the rule of law has multidisciplinary importance for whatever we do in society. We know the Chief Justice leads the Supreme Court and supervises the administration of justice. I've served on the Supreme Court nearly 16 years. The Supreme Court, like any organization, works best when you have a seasoned member leading the court. Whether it's experience in the collaborative appellate decision drafting and issuance process, the mandatory discretionary jurisdiction docket relating to petitions, or the institutional customs and traditions of the court, which are largely unwritten. It is very beneficial to have a seasoned member of the court as Chief Justice. And in our entire history as a state, we have never had an elected Chief Justice who did not first serve on the Supreme Court. At this point, to my knowledge, I've been endorsed by every organization that has made an endorsement in this election. I've been endorsed by 5 former Chief Justices of both political parties, and I would respectfully ask for your support of my election. Thank you.
Thank you, Chief Justice Martin. Let's go now to Judge Lewis.
Good evening. I give all honor and glory to God, and I thank Him for the opportunity to speak with you this evening. My name is Ola Moselle Lewis. I grew up in Fayetteville, North Carolina, the proud daughter of an 82nd Airborne paratrooper. My father retired a command sergeant major. My mother was a primary school principal. I graduated from Federal State University and North Carolina Central University School of Law in 1990. Passed the bar that year, worked in private practice for 1 year, was an assistant district attorney for 2 years, and in 1993 became the youngest district court judge in the state of North Carolina, serving Brunswick, Bladen, and Columbus counties. I served in that capacity for a period of 7 years, where I was a certified juvenile judge, hearing all manner of cases in the district courts. In 2000, my motto became, "Have gavel, will travel." I became a Superior Court judge, a special Superior Court judge for the state of North Carolina, holding my very first session of Superior Court here in beautiful Mecklenburg County. I then became a resident judge in 2002 and have been an executive with the state of North Carolina since 2006, serving as senior resident Superior Court judge. I've tried all level of cases from misdemeanor appeals to capital first-degree murder, and while my opponent was being sworn in as the 28th Chief Justice for the state of North Carolina, there were 2 gentlemen being freed from prison who have served over 28 years for crimes they did not commit, one being released from death row. It is imperative that we have trial judges at the highest court. Thank you.
Thank you, Judge Lewis. Let's go to candidates running for Associate Justice. Let's start with Justice Hunter.
First of all, I would like to thank the Federalist Society and the Charlotte School of Law for giving all of us the opportunity to talk tonight. I know my friend Jimmy and I are always grateful for the chance to talk to lawyers. I am Justice Robert Hunter, Lyle Hunter. I'm the newly minted justice on the North Carolina Supreme Court. I have been appointed by Governor McCrory to fill the vacancy until the voters make a decision. I have been on the court, prior to being a justice, I was on the Court of Appeals from January 1, 2009 until September 6th of this year. Before that, I practiced law in Greensboro, North Carolina for 35 years. I taught in the law schools in North Carolina. I've been chairman of the State Board of Elections. I have done a lot of broad practice. I know legal problems, I know lawyers, and I know what it is to be a judge and a justice. In my decisions, I try to write things that are fair to everyone and also are understandable so that the practicing bar can have the benefit of a decision that they can use. I need your support and would appreciate your vote in November.
All right, and Judge Ervin.
And I would also like Justice Hunter like to start out by thanking the Charlotte School of Law and the Federalist Society for having us here. One of the difficult things about running for judicial office is that we frequently speak to audiences that don't really know very much about what judges do, and so it's always nice to come before somebody before whom we don't have to explain ourselves a lot. For those of you who don't know me, I'm Sam Ervin IV or Jimmy Ervin. I'm a native of Morganton, up at the foot of the mountains. I'm a product of the public school system there. I was a magna cum laude graduate of Davidson College in 1978, cum laude graduate of Harvard Law School in 1981. I practiced law privately in Morganton for a little bit less than 18 years. The firm I was in was a general practice firm that did virtually everything except family law, and we didn't try to tell anybody how to deal with the Internal Revenue Service, but other than that, we tried to deal with everything we did. During the time I was in private practice, I developed some expertise in utility law. In 1999, Governor Hunt appointed me to the Utilities Commission. I served on that body for 9.5 years before being elected to the Court of Appeals in 2008. I served on that body since that time. My judicial philosophy is pretty simple. I think our job is to figure out what the facts are that are usually determined by the trial court, determine what the law is best we can, and try to fairly and impartially, without having any political or ideological bias, attempt to figure out what the right answer is and write an opinion that reflects that. And that's all that I hope to do if I'm elected to the Supreme Court. We also appreciate your vote.
Thank you, Judge Ervin. Let's turn it over to Justice Hudson.
Thank you. At the risk of being redundant, I would also like to thank the Law School and the Federal Society for putting this together and giving us the opportunity to be here. I am Justice Robin Hudson, and I have been serving on your state Supreme Court for the last 8 years, having been elected in 2006. With the retirement of Chief Justice Parker, I became the highest ranking woman in the entire state court system. Before that, I served at the Court of Appeals for 6 years, having been elected in 2000 as the first woman elected to that level of court without having been appointed first. I grew up in Georgia in Greensboro, graduated from public high school, from the public schools all the way through, graduated from Page High School in 1969. Got a BA from Yale in 1973, graduated with the first class that had women all 4 years at that school. And then came back to Chapel Hill to law school, graduated in 76 and started practicing law. For about 25 years, practiced all over the state, handling cases of all kinds for people all over the state, including civil, criminal, from traffic to capital murder, domestics, employment, you name it, including hundreds of appeals, and personally argued before the Supreme Court more than 50 times. I also was in the private sector where I managed the practice and provided jobs in the community and made payroll every month. I cannot think of a better way to put these 38 years of experience than to continue doing what I'm doing and helping to decide the most difficult and complex legal issues facing our state by serving on the Supreme Court. I ask for your support and your vote. Thank you very much.
Thank you, Justice Hudson. Judge Levinson.
Thank you, and again, thank you to everyone for having us tonight at Federal Society and Law School. I'm Judge Levinson. I'm presently a Superior Court judge in this community. I care as much about the system of justice today as I did back in the mid-1990s when I first became a judge. Many of us here can say that we have heard or dealt with or handled every substantive type of legal matter that comes into the courts, and that applies to me as well. And I don't believe that that standing alone qualifies me to serve as a member of the Supreme Court. I believe it's those qualities that we look for in our judges and justices that I have done my best to model all of these years, to act with integrity, to work every day to try to reach the correct legal outcome without any particular favoritism toward anyone, to be a consistent student of the law, and to care deeply about the administration of justice. I'm the candidate in this race who has served as a judge at all levels of our judiciary, with the exception of the Supreme Court. No member of our Supreme Court of North Carolina in the history of our state has joined our Supreme Court after having served as a district and family court judge, as a associate judge in the North Carolina Court of Appeals, as a Superior Court judge. I believe that it matters that we have a dearth of Superior Court experience sitting amongst the 7 members of the Supreme Court. Our Superior Court judges who hear our most complex civil cases and our most complex criminal matters. I'm fortunate to be a candidate, blessed to do work that I enjoy. Just the way that I give back, and I would appreciate your consideration.
Thank you, Judge Levinson. Justice Beasley.
Good evening. I am Justice Cheri Beasley, and I've served on the Supreme Court of North Carolina now for almost 2 years. I, too, would like to thank the Federal Society and the Charlotte School of Law for having us here this evening to share our thoughts and some reasons that we believe that we are qualified to serve on the Supreme Court of North Carolina. In addition to serving now on the Supreme Court, I've served on the Court of Appeals for 4 years, having been elected in 2008. I also served as a district court judge in Cumberland County for 10 years. elected twice and originally appointed. And I resided in criminal court and civil court. I was also a family court judge and a certified juvenile court judge. I do believe that judicial experience is hugely important, given that the Supreme Court is tasked with providing guidance to the lower court as to what the rule of law is in the state of North Carolina. I also believe that there is huge importance in applying the U.S. Constitution and the state Constitution of North Carolina and understanding that those are not just words, but they really are there to offer some guidance as to what the protections of life, liberty, and the pursuit of happiness are for the people of North Carolina. So I'm honored to be here with you all this evening. Thank you.
Thank you, Justice Beasley. Mr. Mike Robinson.
Thank you. Well, I'm grateful to the Charlotte Law School and the Federalist Society for having us. I'm also grateful to you for caring enough about our system to be here tonight. I'm Mike Robinson. I'm a 59-year-old father of 4 grown children and grandfather of 2 beautiful granddaughters. My youngest son is a 3L at UNC, if anybody has a job, as many of you are. I practiced law for 34 years in Winston-Salem. I have focused my practice on business law, representation of businessmen and women and businesses. I know, looking around the auditorium, that I've litigated with and against many of you here tonight. I made a decision in January of this year that it would improve the court system of North Carolina if somebody with business litigation experience was among the 7 justices on the Supreme Court. And so I threw my hat in the ring asking the voters of North Carolina to elect me to the Supreme Court so I can bring that 34 years of experience to the court to help a court that needs that experience. I would be grateful for your vote. My website is votemikeRobinson.com. I hope you'll go and look and learn more about me. Thank you for being here.
Thank you all very much. For the remainder of the evening, we will be asking questions of the candidates for the positions of justices and Chief Justice of the Supreme Court. We will proceed as follows. The first 2 sets of questions will be addressed to all 8 candidates. And we will vary the order of response, and we will begin our first set of questions asking Mr. Robinson to begin the response and move down in this direction. After the first 2 questions, we will direct 2 sets of questions specifically to the candidates for Chief Justice, and then for the remainder of the evening, we will go back to asking questions of all of the candidates. Our first question, and we will ask the candidates to respond in 2 minutes. Our first question is as follows. We are here this evening in part because North Carolina has chosen to select members of the Supreme Court through contested elections. Do you believe that this mode of electing and selecting justices raises any concerns for judges themselves and the public? And if so, how would you deal with these concerns? Mr. Robinson?
Thank you, Dean. When I started practicing law, the senior resident Superior Court judge in Forsyth County was a guy by the name of Bill Wood. And I remember so well that he would always tell the jury after they delivered their verdict 2 things. Number 1, he said, the jury system in North Carolina is far from perfect. It's probably the worst system, except for every other system that's ever been devised to solve legal problems. Everyone has criticisms of the way judges and justices are selected, but as a participant for the first time actively in this process, I must tell you that as people ask me to consider other ways to select justices, they all have problems. You know, the appointive system is a wonderful system as long as you're going to be the person who gets appointed. And I've been through that system at the federal level. I know how it works. At least in this system, the public gets to learn about who the candidates are and make a knowing, intelligent decision about who they want to be on their highest court and at every other level of courts. The implicit criticism most often voiced is that justices are for sale. I received an email just last week where a contestant in this election process referred to me implicitly as the water boy for special interests. And I'm here to tell you, I am not for sale. My integrity is too important to me to consider varying a ruling because someone has made a contribution to my campaign. I think the elective process is a good process, and I think it works. And I think what we need most is intelligent, informed voters who are willing to go to the ballot box on November 4 and cast their ballot.
Thank you. Justice Beasley?
Full disclosure, I was appointed initially to serve on the District Court in Cumberland County, and then I was subsequently elected twice. I was outright elected to the Court of Appeals without appointment, and then appointed to the Supreme Court of North Carolina. And I do think that there's huge value in an electoral system. I think the problem is that often voters are not informed. You have the benefit of a law degree and you've practiced law, but so many people, and I'm sure you receive lots of phone calls from people on guidance as to what to do in these elections if they want to try to do something at all. And I do think that's an issue, that if voters are informed, it's a wonderful system. But I do very much believe in the fact that, in the opportunity to give voters the right to elect those of us who serve on the Supreme Court of North Carolina. But I do think that the money is an issue, and this is more than just a contribution. If people are spending millions of dollars to talk about the goodness of a candidate, that's one thing, or to promote the administration of justice, that's another thing. But when the money is used to disparage good qualified people, or the money is used to deceive, that doesn't provide the proper information to voters. And when that happens, that is a problem. So the election system is great, and I agree with my opponent. At this point, we've not been able to come up with anything better. I think he's right that if you're the one who's appointed, it can be great. But in order to give everybody an opportunity to offer themselves for service, election works pretty well for the lack of information.
Thank you. Judge Levinson?
Thank you. There's disagreement around this question. For me, however, the answer is 100% no. I have said for many years, and I say very fervently now, that the process that we use for the selection of our judges and our justices in North Carolina is fundamentally flawed. And I'm not shy about talking about that. I'm not shy about talking about the process that we use is inherently damaging, can be inherently damaging to the process. And I have said that a hybrid system in North Carolina, which is what the North Carolina Bar Association has advanced for years. I serve on the Administration of Justice Committee along with Buddy Wesser, who is here this evening, who's worked very hard on this issue, along with Carly Mitchell and everyone else who's been in our leadership in the bar for many years, that there's never going to be a perfect system. However, in North Carolina, transitioning us, having a General Assembly considering transitioning us to a hybrid system where there is an appointment process, whether it is by the General Assembly or by the governor, or going back and forth, with a qualifications consideration and a needs matrix consideration on the front end, and then a direct election on the back, on retention elections to give people an opportunity to participate. And I have said that North Carolina should consider looking at a new system. I spoke about this subject in June at the North Carolina Bar Association. If you'd like to see those remarks, send me an email. I do think it's important. The last part of the question is, what can we do? Well, what we can do is try to encourage others who work and participate in this process outside of our own organizations to be positive and honest. I will tell you that I have said that the ads that ran against my opponent were unfair. I've also said that everything that we do will be positive and honest, and I've encouraged everyone external to our effort to be positive and honest. So are we participating in this? Yes. Do 34% of our contributions in this calendar year come from attorneys? Yes. Another 30 to 40% from the business and other industries? Yes. And from the balance of our contributions from other community stakeholders? Yes. Do I think this is the best process? No.
Thank you. Justice Hudson?
Thank you. Well, few issues are as divisive among the members of the bar as this one. And it's been hotly debated as long as I've been involved as a lawyer, so nearly 40 years. I have a slightly different perspective in that I was not appointed to the Court of Appeals or to the Supreme Court. When I tried to get appointed, it wasn't for lack of time. In the 90s, there were openings on the Court of Appeals, and I applied to the governor and got interviewed and did not get appointed. And one of my friends, when some openings came up the following year, 2000, who was very savvy, said to me, you know, you're not going to get appointed. You should just run. Governor probably won't pick you because you haven't spent your career building connections. You've been representing individuals, people that don't have any power. The governor might not pick you, but the people so I ran. And if it had been up to just an appointed system, I probably would not be a judge today. So that changed my perspective a little bit. However, I wouldn't have a problem with some sort of a hybrid system, like a retention election or something like that, but it's up to the legislature to change those rules. And if it was a major change to an appointed system, it would require a constitutional amendment to the state constitution, which is very hard to do. So I always tell people that our task is to make the best of the system we have, since we don't make the rules, the legislature does. This year, but I do have a problem with the money, the outside money especially. The ads that were run against me in April were not just unfair, they were outrageous and false. And they were widely denounced. And I think we have to figure out how to do something about that. Outside groups can come in with their own agenda and spend millions of dollars in North Carolina trying to influence who votes for seats on our state Supreme Court. I think our voters should select our judges. So our task as candidates and yours as lawyers and members of the community is to help educate people about the qualifications and experiences of the candidates so that we'll have experienced, well-qualified people with no political or personal agenda on our highest court. Thank you.
Thank you. Judge Ervin?
I think the problem with any judicial selection system is that you're trying to do, in many ways, two somewhat inconsistent things. First of all, you're trying to ensure that members of the judiciary are accountable in some respects, because our society appropriately thinks that we shouldn't have unaccountable public officials. On the other hand, we also want independent judges. We don't want judges to sit there, wet their finger, stick it up in the air, and try to figure out which way the wind is blowing in order to make decisions. So any system has to balance with those two factors. There are problems with appointments, there are problems with elections. The problems with elections and appointments to some extent have already been discussed, and I won't repeat them. I've both been appointed and elected. I've seen both sides of it. People who favor appointment tend to think that that's non-political. I've never seen a non-political appointment process. On the other hand, people who favor elections talk about well-informed voters, and at least in my experience, you get voters that have dramatically different levels of information about candidates. I don't think we figured out how to solve that problem, frankly, but we're going to have, in my opinion, an elective system for some period of time. I don't see any chance that that's going to be changed in the near future. So I think the thing that's particularly incumbent upon members of the bar is, as one of my colleagues said, make the best of the system we've got. The system that we've got right now is under significant political pressure. We've seen outside money both in the race that Justice Hudson was involved in and the race I was involved in 2012. I don't disagree with Mr. Robinson that none of us would sell their soul for contributions. But that's not the only important question. The real important question to me is, what does the public think? And the public is beginning to think, I believe, that judges are like other political candidates and are elected in a process which militates against a system that works the way they wish to do it. I wish, but I don't know that there's any way we can change it. I'm very, very sorry to say that, but I think that's the truth.
Thank you. Judge Lewis? Oh, I'm sorry.
Thank you. We've heard a lot of wisdom about this subject. This is a subject that's dear to my heart. I think the system can be improved. I don't know that all these various suggestions that we had are improvements or putting lipstick on pig. You're still going to have a pig if you have elections or appointments. In 1972, when I graduated, or 1973 when I graduated from law school, I had a passion for changing North Carolina's method of electing its Superior Court judges. They were nominated by districts and elected at large. By 1996, I had changed that system through litigation and the Equal Protection Clause. And I think there's going to be some young lawyer here that goes to Charlotte or one of the other 5 law schools in North Carolina who will be able to take a look at this and work out a new system where you can have accountability and you can also have some influence by the popular will. Neither system is very good. Ben Franklin in the Constitutional Convention, I'm told, suggested that the lawyers elect the judges so the rest of the lawyers can divide up as clients. I think that's kind of what we do when we elect our district court judges, I suspect. We have kind of a hybrid of that when we go along and do this. But, you know, for now, we're stuck with this. Money is a problem in all levels of government that we elect. And if you read the New Yorker article on this subject in the past couple of weeks, you'll get that. It's a problem in elections, and if political types would stop trying to game the public finance system that we used to have, I thought that was a pretty good system, as did my opponent.
Thank you. Next one.
Ladies and gentlemen, North Carolina is a state of first. We're first in flight, first to drink a cold Pepsi Cola from a fountain in New Bern, North Carolina. And it is my sincere hope that we will be the first state to elect a Chief Justice who is not first served on the Supreme Court. The North Carolina Constitution gives you, the voter, the right to choose your judges and justices. And I have been appointed, but if it were not for the electoral process, I would not be where I am today. Moreover, the North Carolina Republican Party, of which I am a part, has endorsed my opponent. The North Carolina legislature has changed the order of the ballot. It's usually a reverse ABC order in the spring and ABC order in the fall. Well, I used to go around saying I am your first choice for Chief Justice. And that changed about 12:37 one early morning. So it'll be reverse order in the fall. And to add insult to injury, my opponent was appointed by the governor. It is important that we have an electoral process so that you can choose your judges and justices based on not only how long they've been on a court that is one of the lowest ranked courts in the nation, 50 out of 52, according to a Duke study. It is important that judges keep their fairness, their impartiality, and their judicial independence. And I do believe that the Supreme Court ought not be a political arm, but an independent judiciary.
Thank you. Chief Justice Martin.
Well, I think the polar star is public trust and confidence. 22 states select their high court judges through contested elections. 16 use a variation of the Missouri plan, and then 12 use some variation of an appointed model, and including in a few states, selection by the legislative branch. So states, which have always been the laboratories of democracy, there's no perfect way to do this. When I served as chair of the National Judges Organization, I was able to witness the challenges that various states had. And there were challenges with various appointment systems, and many times allegations of political insider trading and campaign contributions to actually be appointed to those seats. But undeniably, when you have contested elections for these important distinguishable role of the judge's only duty, the judge takes an oath to uphold the Constitution and the law. And I think when you have elections, you're undeniably going to have tension that's created between a judge's duty of fairness and impartiality on the one hand, and on the other hand, the demands of the electoral process. And so that's really the key. We do a lot right here. We have a voter guide that is mailed to every registered voter in the state at great expense. But elections work well when voters feel like that they have the information to make informed decisions. Now, we are 35 days from an election, so it is my hope that everyone here considers the qualifications of the candidates and votes for the best qualified people for these offices. Thank you.
Thank you all.
Thank you. Great way to start the forum, addressing what we're all here for, the upcoming election. Next question for all of our candidates. In the past 5 terms, the United States Supreme Court has decided controversial cases about freedom of speech, affirmative action, voting rights, and other hot-button issues. What recent Supreme Court case do you most disagree with, and why? And we will now start with Justice Beasley.
I'm not really sure how fruitful that question is, to the extent that, the Supreme Court of the United States, we're bound by the precedent there, and we often, in the decisions that we make here in North Carolina, must use that court as the very same guidance that we are on the Supreme Court of North Carolina to the lower courts in North Carolina, the Court of Appeals, the Superior District Courts. And so I'm bound by that law that the U.S. Supreme Court sets, and I'm comfortable with following that law, just like I'm comfortable following the law of the state of North Carolina and the U.S. and state constitutions.
Okay, thank you. Judge Levinson.
I would say that I disagree with the extent of the taxing authority that was articulated in the Affordable Health Care Act decision. I just disagree that the taxing authority on the part of the U.S. Congress has that correct. And so if I had to select one, recent case in the last 3, 4, 5 years, I would say that I have disagreement with the taxing authority articulation in that case.
Okay, Justice Hudson.
For me, that one's fairly easy. I have a big problem with the Citizens United decision, which is the one that unleashed all the outside money with limited disclosure and allowed the kind of outside attack ads that ran on me in April and on Judge Ervin in 2012. There's another case which escapes me from Arizona, in which the Supreme Court decided that the rescue funds provided under the system of public financing was unconstitutional. And those two decisions together rendered any attempt at a public financing system that tried to take a lot of money out of the system, political money out of the system, made it virtually impossible to do. So it's created problems for all of us, and I think that the outside money flooding into North Carolina and our judicial races is a bigger problem in the judicial races than it is in the more political branches, because judges are not supposed to have a political agenda. And when outside groups come in with a well-stated agenda of spending money around the country to influence Supreme Court seats around in a number of states, the implication is that those judges should have an agenda that they are happy with. And that is just not what our job is. We take an oath to administer justice without favoritism and to be fair and impartial. And that implies that we should have no agenda. But the outside money, I think, runs a risk of jeopardizing that. It also runs a risk of undermining public confidence in the court, and also of discouraging good, qualified people from wanting to serve, because who wants to be subject to that sort of thing? And I think we have to figure out a way collectively to address that. There are only two ways legally to change it. One is to amend the U.S. Constitution. The other is for the Supreme Court to change their mind. The other way that might work is for it to stop working. It hasn't worked so far in North Carolina, and with your help, it will continue to not work, because our courts are not for sale.
Thank you, Justice Hudson. Judge Ervin.
I guess I'm going to be difficult at this point, which for those of you that know me is probably predictable. I have consistently, in 3 campaigns, refused to say what I thought of particular decisions of the court. And my reason for that is a sense that ultimately what's important is the ability of the judge to fairly and impartially apply a particular decision. And if I was to get up and say I agree or disagree with any decision of the Supreme Court, and then wind up with a case in front of me in which somebody is relying on that case, there's going to be the suspicion in the back of somebody's mind. If I said that I disagree with it, that I would try to read it in the most crabbed, restricted method possible, or alternatively, if I agree with it, I would try to expand it broadly and give everybody the benefit of the wisdom of that decision. And so I think that if we start commenting on the wisdom of particular cases, we lay ourselves open to a possibility that litigants who come before the court may question our ability to be fair and impartial. And so for 3 elections now, I have consistently declined to comment on the wisdom of decisions of the U.S. Supreme Court, the North Carolina Supreme Court, or the Court of Appeals. Because ultimately what a judge needs to do above all else is not do anything that impairs public confidence in the fairness and impartiality of the judiciary. If we do that, then we've harmed the system.
Well, I can be just as difficult as Judge Ervin. And I want to say that I think this question's a little unfair. Ask judges to comment on the wisdom of our voters. And I think it's unfair for this reason. We are all lawyers, and we are all judges. And even though a higher court may sometimes give a decision that is mystifying to us, it is the law. And our respect for the law has to trump temporal political issues that may be one way or the other. And we have to enforce the law, and we have to enforce it with a rigor that a lot of folks don't like. Now, so I just think it's wrong for us to comment on what the Supreme Court does or does not do. And so I'm going to decline to answer that question. I would like to take up on something that my friend Jenny said that I think is true. I think all this talk about money and judges and buying and selling of elections of judges in this state is misplaced, because it also undermines the public's sense of integrity in the judges that are elected. I think there's not enough money to really influence the wisdom of the people in electing the judges. I think it might affect a couple percent one way or the other. Maybe that's enough. But basically, I think that we ought to be in the business of promoting the fairness and integrity of the judges. I can't be bought. I don't think anyone on this panel can be bought. And I think that's true of most judges, because we're independent justices.
Judge Lewis.
I am not going to comment on any decision by the highest court in the land. However, what the question does bring to mind is the importance of the high courts to issue decisions that will be the law of the land for lawyers and litigants to follow. And our North Carolina Supreme Court has woefully failed in this area. North Carolina Lawyers Weekly highlighted only 17 opinions year to date. Last year, only 27 opinions by the North Carolina Supreme Court. It is important that this court take on substantial issues of constitutional law that impact greatly this state, and that the North Carolina Court of Appeals, who writes on average of about 1,500 opinions a year, each of the 15 appellate judges averages 100 opinions a year apiece, that this court do what it is duty-bound to do and work and write more.
Thank you, Chief Justice Martin.
Well, I don't know which question to answer, but I will say that my administration of justice plan provides for increasing the number of fully briefed and argued cases with the Business Court Modernization Act. We will also have additional appeals brought from that source. I've authored over 400 appellate decisions, and I'm the only candidate in this election who has actually authored an appellate decision. And I agree with the theme that Justice Hunter articulated and elaborated on, and that is that as lawyers and judges, we are the guardians of the rule of law. And I think that instead of attacking courts and attacking justices, that we should unite to promote respect for the role of lawyers and to promote the respect for the role of judges. If I was pressed to say, well, what is the one issue over the years that seems to potentially elude lower court judges and attorneys and justice system stakeholders, I believe our Fourth Amendment jurisprudence has become so fact-dependent in terms of you can have one factual nuance and have a totally different outcome under the Fourth Amendment. And I think probably a reassessment of how we better balance the right of Americans to be free of search and seizure, absent individualized suspicion, and the legitimate needs of government to perform searches and seizures.
Thank you very much. Oh, I'm sorry, Mr. Robinson. You gotta be fair in this crowd. I understand that.
Well, it appears that one of the good things about being the last person to answer one of these questions is you can get a sense of the flow and temperature in the room. And since everyone else seems to be wanting, except one of my colleagues, to not answer the question, I will learn from their example. But I would like to highlight one case, and it's not because I disagree with it. The last decision, as I recall, decided by our U.S. Supreme Court at the very end of the 2013 term was a case that originated in North Carolina. It was a case dealing with personal jurisdiction and whether B.F. Goodrich could be held to come to North Carolina to defend the case that arose out of an accident that occurred in France. Our North Carolina Supreme Court declined the petition for discretionary review of the case for whatever reason was sufficient to the members of the Supreme Court. But the U.S. Supreme Court found it of sufficient importance to take that case and to reverse the Court of Appeals. I must tell you, as a lawyer practicing in North Carolina, I found that remarkable, that our Supreme Court did not find sufficient importance to take a case and the facts and law was deemed sufficient by the highest court of the land. As members of the court have come through my office in the last several years, and I'm sure they come through many of yours, I've asked the question, why are not more petitions for discretionary review granted, especially in the civil arena? And the answer is always, I'm only one vote, it takes three. When 5 people come through my office and say, I'm only one vote, it takes 3, even I can do that. And so my hope is that if somebody with civil litigation experience who's focused in that area gets on the Supreme Court, there will be an emphasis on more civil cases being decided by our Supreme Court.
Thank you very much. We are now going to direct 2 sets of questions specifically to the candidates for Chief Justice. The first question will begin asking a response first from Chief Justice Martin, and then the second one will ask for a response first from Judge Lewis. The first question is as follows. Is the level of funding for the North Carolina court system appropriate? If not, what additional functions or services is funding needed for, and how would that additional funding be obtained?
Well, before I became Chief Justice, but recent in time to that appointment, a study was done by the North Carolina Administrative Office of the Courts using National Center for State Court standards, and it reflected a deficit of over 600 positions for our court system. Now that is significant for a system that has around 6,000 employees, and using rough math, 10% deficit. So I think that when we consider funding, we have to look at the situation globally and try to understand why do we have funding and how is that so tied to the investigatory and adjudicatory function at the county courthouse, out in the counties. And undeniably, when I go to these areas and tour the DA's office recently in one area, we had the receptionist had been let go. And so you had higher paid attorneys and paralegals taking turns out in the receptionist seat. And guess what? When they were out there reading people and taking calls, they were not able to work on their cases. And we know the speedy trial implications and just fundamental fairness of trying to have a prompt adjudication of in criminal cases around our state. So yes, I do believe that if you look at the historical data, we used to have a weighted average of about 3% of the state budget for a co-equal branch of government. We have now fallen to 2.24%. And all of you know with the numbers involved in the state budget, that's real money. And so I believe that if elected as Chief Justice, I'm going to be convening a commission to look at how innovation and re-engineering and better funding can make sure we strengthen our courts in every way possible.
Thank you. Judge Lewis.
As the senior resident Superior Court judge for beautiful Brunswick County, I am in charge of our budgets. And I understand what is needed because I am where the rubber meets the road every day. I have had court sessions canceled because of lack of court reporters. We have had cases to be continued because we didn't have the DAs available to try the case for whatever reason. I also know that we can bring cutting-edge justice on shoestring budgets. We have 5 therapeutic courts in Brunswick County. Mecklenburg County is the only other county that I'm aware of with almost as many therapeutic courts. And our therapeutic courts, the first in the state of North Carolina, Night Drug Treatment Court, and Mental Health Court, a DWI therapeutic court, sex offender therapeutic court, and domestic violence therapeutic court. We run these courts on $600,000 worth of federal grants and also input by our local county commissioners. It's about bringing stakeholders to the table. It is about making the legislators accountable to the third branch of government and not by raising court fees every time they convene for a session. My father told me that the time to show leadership was before you indeed become the leader. And I have done that throughout my career, and that is what I will bring to the office of Chief Justice. I don't need a plan, I'm already working it.
Thank you very much.
Thank you.
Thank you. This next question is also directed towards our candidates for Chief Justice, and with this one we will start with Judge Lewis.
Yes.
What is your perspective on the level of cases making their way through the North Carolina judicial system? Do you see any way to improve efficiency, and if so, how would you do that?
The lower courts are running like well-oiled machines. I do not have any case backlog in Brunswick County at the Superior Court level, nor do we at the District Court level. And I think that if you will look at the case filings across the state of North Carolina, some 2 million cases filed in the lower courts each year. These District Court judges who are in the audience and the Superior Court judges are working every day to get cases moved through the system. Now, my opponent will say to you, well, she's got the lowest court time on the bench in the state of North Carolina. But what he's not counting is the time that I'm writing or signing search warrants at 2 a.m. in the morning, and the time that we spend making sure cases run through mediation and negotiation and getting settled before there is a need for trial. Though we see some 2 million cases at the lower courts, the North Carolina Supreme Court is hardly at work. They do not convene the months of June, July, August, or December. When they do convene, it's a mere 2 days per month, usually no more than 6 hours per day. And I'm certainly on the bench more than 16 days a year. I believe that in order to make our system work at the appellate level, we need judges and justices working as hard as the lower courts work. Our percentage rates in Brunswick County for the Superior Courts are at 115%. That's 15% above and beyond the requirements that's promulgated by the North Carolina Supreme Court. We are working in the lower courts. The appellate courts need to work as well.
Thank you, Chief Justice.
Well, I served on the Superior Court, and I served on the Court of Appeals, and I served on the Supreme Court. And I'm the only active judge in the state that's been at all 3 of those levels. And I tell everyone when I move around the state that justice begins and ends at the county courthouse. There's a lot of areas for efficiency. In 1996, we were the first Supreme Court in the country to have e-filing. It was so impressive that the clerk of the U.S. Supreme Court traveled to Raleigh to see how the system worked. And we know that through efforts with Judge Daniel in the business court that we had e-filing in the business court. It is time to place e-filing in every county courthouse, and we can do this. I have talked to directors and chief justices around the country, and one of my top goals next year will be getting e-filing at the county courthouse level. The reality is that we can always be more efficient in how we use our resources, but we also have to have adequate resources to make sure we have people in place where clerks' offices are not having to close days of the week, as we've seen in parts of the country, and to make sure that we don't have family law cases languishing for 6, 7, and 8 years, because there are not individuals in place to try these cases. Now, the reality about work ethic is that I have never worked harder on the Supreme Court. In other words, as a Superior Court judge, moving up to the Court of Appeals and then the Supreme Court, and I'm not speaking for all 7 justices, this is a group that is working all the time. And I've never worked harder at any level of the courts than at the Supreme Court. And there's an increasing number of administrative and other issues that afflict courts nationwide. But I'm convinced if we can install a central staff pilot at the Supreme Court, as we've used successfully at the Court of Appeals, that we can and will increase the number of fully briefed and argued cases at the court, and that is my plan. And it's good to have a plan, because if you have a plan, you can decide how to do it, conceptualize, and then go into carrying out that plan.
Okay, we will now return to questions for all 8 candidates. And to vary the order, we will begin this question, asking Justice Hunter to begin. We will move in the direction toward the door. First question is as follows. What is the most important principle underlying your approach to judging, and how would you explain what that means in practice?
Well, Jimmy and I have had this debate when we were in Raleigh. I think fairness is the most important quality that you have to have. For those of you who are interested in a longer version of this answer, you can go to WRAL.com and watch my 40-minute discussion of this, my installation. For those of you who are interested in the short version, I think in most cases, the routine application of settled law is what we do. That takes care of about 98% of our work. As Jimmy suggests, finding the facts or reading the facts, applying the law that's settled to the case. I think that he and I have different experiences in the law. I've given you a hint about what my view of fairness is. And it comes from my work, I think, in voting rights and equal protection work. The equal protection clause at base is really about fairness. Now, by these remarks, I'm not suggesting that Jimmy is not fair. I've seen him do equity, so I know he's guilty of fairness. But occasionally, when the moon is blue and the dogs are howling, we have different outcomes because of our different philosophical approaches. I, of course, go through the facts and the law and apply the statutes, as he does. But I always look at what I call the buoyancy of the judicial system that moves juries and children understand, and that is, that are we ending up with a fair, practical result that makes sense? And I don't think our U.S. Supreme Court would have those problems if they took a little bit of my judicial philosophy and applied to some of these questions.
Thank you.
I discussed very briefly and hurriedly this question in my opening statement, but let me come back to it. I mean, it seems to me that as a matter of basic civics, the ultimate job of the court is to, for the most part, interpret provisions of law adopted by others. They may be constitutional provisions that were adopted by the framers of the U.S. Constitution as amended by the framers of the North Carolina Constitution, and may be legal principles derived from statutory enactments made by the General Assembly, or they may be derived in some instances from common law principles that go back to Great Britain. But ultimately, as I said, it seems to me that the job of an appellate court in particular is to take a look at the facts, which were determined at the trial level for the most part, determine what those facts mean, determine what the applicable legal principles are, and then to try as best we can to apply the law to the facts. I don't think that judges are sent to courts for the purpose of making subjective determinations about what how a particular case ought to be decided. If we want to do that kind of thing, we can always run to the legislature. But it seems to me instead that we are to do the absolute dead level best that we can to try to apply the legal principles that we get from the sources that I delineated to the facts as we have them. In the event that we start making subjective decisions as to how cases come out, then it seems to me that we move away from a law-based system of justice. Ultimately, it seems to me what fairness means is that a party has the law as it exists, applied to the facts fairly, that all people are treated equally, that nobody is subjected to differential treatment on the basis of some characteristic other than what the law provides. And so that's, in essence, what my judicial philosophy is. It's been what I did at the Utilities Commission, what I tried to do at the Court of Appeals, and what I would try to do at the Supreme Court if I'm fortunate enough to be elected.
Thank you, Justice Hudson.
Thank you for that question. My approach to judging is completely informed by the oath that we take, which is to administer justice without favoritism and to be fair and impartial. And that means going into each and every case with an open mind and look at both sides of the case and deciding the case fairly. Now, in so doing, I think it informs that process to have experience at multiple levels of court and understand the practical realities of how that works. And in addition to not bringing in sort of a personal or political agenda, I think it's very helpful to have tried cases as I have in the district court, superior court, administrative agencies. I've been a fact-finding part-time trial judge for OSHA cases, as well as appellate judges when I was still in law practice, served at the Court of Appeals and on the Supreme Court. And to take all of that and apply some common sense and practical understanding of how things play out in the courtrooms around the state in order to write decisions. Because part of our job is, once we have reached a decision, is to then issue a written opinion that can be useful to the bar and to the public and to the lower courts, and try to write that in a way that is clear and helpful. And all of that is part of my approach to judging, which is driven, again, by the oath that we take to be fair and impartial and bring no political or personal agenda to the bench. Thank you.
Thank you.
Okay, thank you. Two parts of the question. The first about the most important principle, and I would say the consistent, educated application of the law. That means having an informed judge on the bench. And frankly, for that to be done with a judge and an individual who, frankly, does not care about whether the outcome pleases the folks who are involved. Those members of the bar statewide who've been with me in court at all levels, we are there as an objective arbiter of law and to make decisions that comport with the facts and with the law. And we have seen, and I'm not suggesting anyone here, but in our community statewide, there are judges who have concern about whether their decisions please the parties and lawyers who are involved. And that's a concern. So as it relates to the most important principle, I would say, of judging, I would say consistent, informed application of the law. I was the first judge in decades, perhaps in North Carolina, certainly in memory for all of us who have silver hair now, who entered a J&OB in favor of an accused in an individual burglary matter in Charlotte, right here in Charlotte, the Superior Court. The legal decision itself, frankly, was not terribly challenging. I was satisfied. Frankly, it shouldn't have advanced. I shouldn't have allowed it to advance, but I was persuaded that it should advance to the jury. And then upon reflection, after having lawyers brief it, I entered judgment in favor of the defendant instead of sending the defendant to prison for 10, 15, 20 years. What surprised me was the public vitriol that followed. Of course, I couldn't say a word because of the judicial code, but that illustrated to me the lack of confidence that folks have in our judges and in our court process. But I would say that's an illustration, that second part of your question about the practice and how that falls out in practice. An easy legal decision, but one that was not received very well in the community. Thank you. Beasley.
An important principle is fairness, and fairness includes the ability and the willingness to apply the law as it is, to include the constitutions of the United States and the state, as well as state law. And it's important to apply the law as it is and not as we may wish it to be. It's important to be learned and to fully understand the importance of what's at stake, and to know that at the Supreme Court of North Carolina, that as we are applying the law to the case that comes before us, that we're also mindful that the cases that the opinions that we render really apply to parties who may never come before us. And so I think the human element of that is important as well. You know, some of us up here talk about having served as a trial judge, and you all know that at the Supreme Court we don't see witnesses and we don't see parties. But I think it's important to appreciate that every single day on the Supreme Court of North Carolina that we do make decisions which affect families and small businesses every day. And I think it's important to be mindful that as we follow the law, that the law really does apply to people and to communities, and to think about the effects of those, the decisions that we have, apply practically.
Thank you.
Thank you. I had the privilege of being at Rich Dietz's swearing-in ceremony last week, our newest member of the Court of Appeals. His ceremony was remarkable for two reasons. Number one, the brevity of the recipient's speech to those assembled, and second, his candor. In less than 5 minutes, he said something I thought was pretty noteworthy. He said, "I realize that my job as a Court of Appeals judge is to get it right. That's job one." And I agree with him 100%. The abiding principle of the Supreme Court justices is to get it right on the law under the facts. Fairness is an important principle, but it's also a squishy principle, and it's one that's very difficult to define. And I think everyone up here wants to be fair, but I think it's also important that we understand that the court needs to get it right on the law based on the facts as presented. As I go around the state during my campaign, I am amazed at when I talk to people and I say, what is it that most concerns you about the court system in North Carolina? The overriding response I get is the uncertainty about what's going to happen if I am involved in the court system. I think people need guidance and guidelines and clearly set forth as a Supreme Court what the rules of the road are for people doing business and living in this state. And I hope to do that.
Thank you. Chief Justice Mark.
The consistent and predictable jurisprudence has to be a goal of any legal system. And at least to some degree, when you have the uniform application of the law, and that's one thing from the appellate courts you're really trying to ensure is that we have a uniform system, unified court system, to make sure that the citizen of Manio and Murphy, same facts, same outcome. Because in one sense, the uniform application of the law is justice. And while I believe that the cardinal duty of every jurist is fairness and impartiality, the ability to not prejudge, be open-minded, make sure you hear from both sides before you actually come to a decision. But I do think fairness sometimes, every person up here has talked about fairness, but what is the content of fairness? So I think fairness and equity are inherent in every legal action, but also fidelity to the Constitution and the law, and to make sure that stare decisis and concept of judicial restraint are used when necessary. Because I think things generally work best when most policy questions are resolved in an atmosphere where you have committee hearings and members of the public who are actually able to come in and give their opinion on things. Judges deliberate in secret, but necessarily there are times when judges are required to come forth and to resolve policy issues that have been left unresolved by the legislative body. And I think judges have to be willing to make those tough decisions when necessary.
Thank you. Judge Lewis.
Consistent jurisprudence. Here tonight, he's saying he favors the electoral process, and with the American Constitutional Society, he believes in lifetime appointments for judges. Ladies and gentlemen, I have been a litigant. I have sued an individual for libel pro se for a Facebook post, was kicked out of court on summary judgment. My matter went up to the Court of Appeals. I was told I didn't have 2 legs to stand on, but at least one, and went back before a judge and jury for successful jury verdict or $105,000 verdict that I'll never collect. I've been on both sides of the bench. I understand what it means to have fair and impartial judges review a case and sit and preside over cases. I am unbought and unbossed, as Shirley Chisholm used to say. And this is what North Carolina deserves in a Chief Justice. Not someone who's going to appoint a 3-judge panel that the governor wants or that the legislative body wants. A Chief Justice that will appoint a fair and impartial 3-judge panel. I believe that judicial impartiality and fairness are the cornerstones of what makes our system work. Thank you.
To make the most of our time and to make sure that we are able to get out on time, we'll ask one final question, a little bit more personal tonight. And with this question, we'll keep it at 60 seconds. And this question will start with Judge Levinson and work down to his right. How does your past life experience shape your understanding of the law?
Well, thank you. I mean, I've spent my career working on building transparent, credible court systems, whether it's statewide or whether it's overseas. I'm a candidate who has seen firsthand individuals who've been denied procedural and substantive due process as a result of my work in Iraq and Afghanistan, where I worked for the U.S. Department of Justice in Iraq and with the USAID affiliate working on civil courts, standing up civil courts in Kabul. That matters, and I will tell you that I'm the candidate in this race who has applied the Constitution in the courtroom, presided over a jury trial, actually sentenced an accused to prison, decided whether parental rights should be terminated for a child or whether a child should be reunified with a child, exercised discretion inside the courtroom, dealt with motions for appropriate relief and petitions coming from our quasi-government agencies, final agency decisions. I think that matters. The collection of my experience, my passion for the court, my everyday commitment to taking justice and administration of justice very personally informs my work. And I'm the candidate who has 60 seconds.
Yes, you. Little extra, but thank you very much. Justice Hudson.
Yes, thank you. Well, in my 38 years as a lawyer and the last 14 as a judge, well, total 25 as a lawyer, 14 as a judge in Court of Appeals and Supreme Court, I've handled every kind of case that the Supreme Court sees, either as a lawyer or as a judge or both. And I think that benefits, and it certainly informs the decision making that I do on a daily basis. Our job is to decide disputes that people bring to us. We don't make the law, the legislature does. We then apply it consistent with the state and federal constitutions. And I think that having that practical experience is very helpful. I also have 2 grown children, both of whom teach second grade in public schools, my son in Wake County, and I have a 1-year-old granddaughter. And a lot of what we do is about helping to form the kind of quality of life in the future that we're going to have in North Carolina by what kind of system that we have. So all of that life experience goes into informing what I do and helping to, with my decisions every day, to try to get it right in every single case.
And thank you, Justice Hudson. Judge Ervin.
I think it was Tennyson that said that we're all a part, I am a part of all that I've met or something like that. I think that's true of all of us. I mean, I am, as I said, in my statement, from a small town in western North Carolina. I grew up there. One of the advantages of living in a small town and growing up in a small town is that you were exposed to all kinds of people because society is sufficiently small that everybody knows everybody. I went back to practice there in 1981 after I graduated from law school and passed the bar. And I think the thing that has informed the way that I look at the court system is the sense that we have a remarkably diverse population in the state, ranging from people who are living from day to day to people who run large industries and employ thousands of people. And so I think that the breadth of my perspective is what I've gotten out of the law. I've had a very diverse practice and showed me a lot of different parts of North Carolina, the way that the law affects many different North Carolinians, and I'm a better person for that experience.
Thank you, Judge Ervin. Justice Hunter.
I'm the first lawyer in my family. My dad was a builder. My mom was a school teacher. I went to public schools, and I went to Chapel Hill. I passed the bar. I got out and hung out my shingle in Raleigh, and then I hung out my shingle in my hometown in Greensboro. I've done everything you can possibly do as a sole practitioner. I've been a little firm. I've been a 200-man international firm. I've done international work. I've done claim and delivery. I've done collection work. I've done about everything you can do as a lawyer, with a few exceptions. I have to agree with my friend, the IRS has always proved a mystery to me. I've tried to stay away from it. So basically, I think that we all are a product of our environment, and I'm no different. I'm going to be fair to everybody that comes before me, and I understand most of the problems that I'm given to divide on. Thank you.
Thank you, Justice Hunter. Judge Lewis.
I bring 24 years of legal experience with me to the high court. There's literally no part of the judicial system that I've not been a part of in some way or another. I have a brother serving 20 to 25 years as a habitual felon. Started with a little bit of marijuana between friends that fueled an addiction, and 3 strikes, you're out. That old adage, when one person in the family does time, the whole family does time, is certainly true. So I understand the importance of what is happening to everyday people when they come before the courts. I stand ready to lead day one, and I sincerely hope that you consider my candidacy with your prayers, your thoughts, and your vote. Thank you.
Thank you, Judge Lewis. Chief Justice Martin.
Well, I was raised by a career Air Force officer and a classroom teacher. And so at times we moved around, and learning to appreciate new and different environments was an early part of my life. I'm married, I have 5 children, and I've engaged in private practice. After law school, I served as a federal law clerk. I had a short stint in the executive branch of state government as legal counsel to the governor, and I've served at 3 levels of the judicial system. And from those experiences, I have learned that we have wonderful people in our bar and our justice system. And working together, there's not one challenge that we cannot confront and tackle that we have in our justice system. I have worked with 4 chief justices and seen things that worked and things that did not work. And so I would respectfully ask for your consideration and support for the election as chief justice. Thank you.
Thank you, Mr. Robinson.
Thank you, and thanks again for being here tonight. In addition to practicing law for 34 years in the state and federal courts of North Carolina, for the last 5 years I've had the privilege of being an elected state bar counselor and currently chair two of its committees, the Authorized Practice Committee and the Special Litigation Committee. I've had the privilege of working with the likes of Judge Frank Whitney. We seem to find ourselves in the minority sometimes, but it is worthwhile service. You know, the times are changing. The law practice ain't what it used to be. It certainly isn't what it was in 1980. There are lots of different kinds of diversity. One of those kinds of diversity is having a Supreme Court that has people with different professional backgrounds on it. And I think it's time for the voters to consider that and to consider the need to have someone with a business background on the state's high school. Thank you.
Thank you, Justice Beasley.
I've had almost 16 years of judicial experience, having served now on the Supreme Court of North Carolina, the North Carolina Court of Appeals, and as a district court judge. You know, the other sort of life-changing experience I had was I never thought I would be an assistant public defender, and I never thought that I would have the opportunity to serve a population like that, if you will. And the one thing that it taught me was just the power of the human spirit, and in all the ways that we think that we are so different in what we do, we're often very much the same. I'm also a wife. I've been married for 21 years, and my husband and I have twin sons who are 13 years old and just started high school, and so that's the other piece of my life, which is more than interesting. I'll tell you, my 13-year-old's wearing a size 14 shoe, and so, but I do think that, yeah, tell me about it. But I think all of those experiences really bear well on making good judges and justices. So I do ask for your support. Please go to www.justicecheribeasley.com, and I really appreciate you all being here this evening.
Thank you very much to all of the candidates for being here tonight, and thank all of you for attending to hear what they had to say and for answering our questions, whether you like them or not. Some of you were difficult, but it was okay because it was great. I thought it worked out well. So this concludes our forum. Remember, November 4th is the general election. Big day for us at News. I'm sure you guys are all getting ready for it yourselves. The goal tonight was to provide you with information when you do hit those ballot boxes so we can all learn a little bit more about the candidates running for Supreme Court. And we hope you and all of us, and the candidates, have succeeded that tonight. Thank you so much.